A very good evening to everyone. Today, we'll be discussing one of the Supreme Court case law that have come out in the last financial. And this case is all about deciding upon the taxability of non-compete fee. To give you people a background of non-compete fee, it's a payment, either could be a lump sum payment or a periodical payment that is made by one person to the other person so that a third person does not enter into our domain of business activities. And why do you do that? Because when a third person is going to enter into my business, obviously he's going to take away my customers, and once he take away customers, the revenue is going to take a hit and the profits are going to come down, my market share is going to take a hit. So this would sort of disrupt my monopoly or my market share in the business. So in order to avoid all these things, what businesses generally do is they either make a lump sum payment or a periodical payment to a person so that that particular person or a third person does not enter into my business for a certain period of time. So this is what you generally call as a non-compete fee. So with that background in mind, let's move further with the presentation. Credits to Epsiba for working on this presentation. These are the legends that have been used in the PPT. So once we upload the presentation, it will be very useful for your reference. And this is the presentation schema upon which you'll be approaching this PPT. So we have the facts of the case, issues and orders, contention of both the parties, that is the revenue and the assessee. Then we have the most important observations of Supreme Court, and finally we have the conclusions. So we'll start with the facts of the case. So the present case relates to assessment year 1995-96. And the assessee is the chairman and managing director of a company named CBDL. And this company is into manufacturing of beer and Indian-made foreign liquor. And it has got a manufacturing plant at Meerut. So the assessee and his family holds a controlling stake of 57.29% in CBDL. And there was a Supreme Court directive stating that the company's manufacturing activity at the plant of Meerut shall be suspended. Till what time? Till a secondary effluent treatment plant is installed and is made operative. So since the company's manufacturing activity at Meerut plant got suspended, the controlling block of shares held by the assessee as well as his family, they were sold at rupees 30 per share, whereas the listed market price of share was only rupees 3. So it's a very important point to note because we will have a lot of deliberations going further. So the sale price was rupees 30 per share, but the listed market price of the share was. So as a result of this transaction, okay, there were two sort of considerations that was getting paid out. So one is obviously the management and control that totaled to somewhere around some 55 lakh rupees, and this was actually paid to the assessee as well as his family. But apart from this sale consideration, which was paid by way of a memorandum of undertaking, a deed of covenant was also imposed. What is this all about? A deed of covenant is imposed to prevent a particular person or restricting a particular person from doing a particular act or something. So in the present case, it was to restrict the appellant from carrying out directly or indirectly any manufacturing or marketing activities relating to Indian-made foreign liquor or beer for a period of 10 years, right from the date of handing over. And for this, he was paid a non-compete fee of rupees 6.6 crores. So in summary, there are two agreements, there are two separate deeds executed as such. One is the memorandum of undertaking, the other one is the deed of covenant. So through the memorandum of undertaking, the assessee is getting the consideration for sale of shares, and through the deed of covenant, the assessee is getting consideration by way of non-compete fee to restrict him or refrain him from entering into the manufacturing of beer business. So far looks everything great. So what was the issue that was actually put forth before the Supreme Court? Whether the non-compete fee of rupees 6.6 crores received by the assessee should be treated as a receipt for compensation for termination of management in CBDL and should be taxed under 28(2)(a). So what is this 28(2)(a) all about? So to give you guys a small background, I've given a note over here. Any compensation received by any person in connection with termination of his management or modification of terms and conditions shall be taxed under the head PGPP. So the revenue was arguing that this 6.6 crores is not a non-compete fee. This 6.6 crores is received in connection with termination of its management, and it gets squarely covered within the ambit of 28(2)(a), and it's a revenue receipt, and it's taxed under the, and should be taxable under the head PGBP. So that was the contention of the revenue, and this was the issue that was taken to the Supreme Court. So we'll see what happened further. So we had some interesting orders that have been passed into the appellate forums. We will discuss them in brief. So to give before I start with the AO's order, I just want to give you a small brief. Assessee was the owner of a company named Maltings Limited. This Maltings Limited, Maltings was a very small company, and this was actually incurring losses in the previous year. So the assessing officer noted this particular point and stated that there is no real competition that could be envisaged between a giant like SWC Group and a loss-making dwarf like Maltings Limited. SWC Group is the company to whom the shares are sold, and SWC Group is a giant in terms of its size, revenue, profit, everything in every aspect. SWC Group is a giant, but Maltings Limited, Maltings is a very small company. In fact, it's a loss-making company, and Maltings Limited could never be a competition to SWC Group. That was a very strong contention of the AO. As a result, what he said was like, the entire deed of covenants through which the non-compete fee is paid. No, it's only a colorable device to evade the taxation from the purview of 28(2)(a). So that was a very strong point that was said by the AO. Second point is, generally a deed of covenant will have a penalty clause, because in case you deviate from the agreement, obviously you're gonna be penalized for that. So, but this deed of covenant that was executed did not have a penalty clause or such. And going further, even the son of the appellant was also a joint managing director in the company, but he was not paid any non-compete fee. The assessee was a managing director. Even the son of the appellant was also a joint managing director in the company, but he was not paid any non-compete fee. So the entire payment of rupees 6.6 crores was only a colorable device to evade the payment of tax. So that was the stance that was taken by AO. Very interesting stance. But when the appeal went to CIT, it got dismissed due to some reasons. Then we have the order of the ITAT. At the ITAT level, the case was decided in favor of the assessee by the ratio of 2:1. So the learned accountant member of the ITAT forum stated that it's not taxable under 2D2A, but the learned judicial member, that is the second member, agreed with the stance of the AO and stated in favor of the revenue department. So the case was 1:1. So the case was referred to the third member, and third member stated that the case is actually in favorable of the assessee. So finally the decision turned out to be in favor of the assessee at 2:1. So the case again went to the High Court, and High Court gave a very interesting judgment, clearly deviating from the stance of the AO, ITAT, even as the assessee. The High Court went on to state that rupees 6.6 crores received by the assessee is not in consideration not in consideration for refraining from carrying on a particular business, but this was completely connected with the sale of shares as well as the loss of control. So since shares being a capital asset, transfer of capital asset would attract capital gains. So High Court went on to state that this is capital gains, and assessee shall be subject to tax on the same. So this was the stance of the High Court, completely deviating from the stance of AO, ITAT, as well as the assessee. So we will see what are the contention of the parties. So as discussed in the previous slides, the High Courts went on to state that it's in the nature of sale of shares, and the deed of covenant was only a sham transaction to guise the evade tax. And even if it's not considered, suppose even in case it's not considered as capital gains, it would anytime fall under the purview of 28(2)(a), as was held by the AO and the minority judgment of ITAT. So these were the two important contention of the revenue. So going further, if you see the contention of the assessee, one important, very important, a strong point that was put forth by the assessee was only substantial question of law could be taken before the High Court, and the High Court cannot pronounce a judgment that is outside the purview of substantial question of law unless and otherwise it follows the specific procedures. So we will discuss this in detail in subsequent slides. So for time being, I'm keeping it on hold, but this was a very interesting point, very important point that was put forth by the assessee. And assessee went on to state that the decision of the learned accountant member and the third member of ITT should have been followed, and non-compete fee is a capital receipt and it's exempt in nature. So these were the stands of the assessee. So we will have a look at the observations of the High Court. So as I said, no, if you want to make an appeal before the High Court, it should be a substantial question of law. So an appeal shall lie out of every order passed by the ITAT if the High Court is satisfied that the case involves a substantial question of law. If the High Court is satisfied with the question of law, substantial question of law, it shall formulate that question. Hence, appeal shall be heard only on questions so formulated. So very clear from the these 3 points that only a substantial question of law could be raised before the High Court. So what is a substantial question of law? Where the decision is not something very apparent, it's something which is highly arguable, debatable, and it's not previously settled by any court of law. So that's what you generally call as a substantial question of law. So in case High Court wants to pronounce a judgment on any matter other than a substantial question of law, a proper notice has to be sent to both the parties, and opportunity of being heard should also be given. And non-issuance of such notice would make the appeal illegal, and it amounts to denial of natural justice. So if you see the grounds of appeal, I have now put in the left side the grounds of appeal that was put before the High Court. Okay, though whether ITAT has correctly interpreted Section 22A, whether it's revenue nature or capital nature with respect to taxation of non-compete fee, whether ITAT actually failed to distinguish between what is revenue or what is capital, and whether the learned judicial member was correct in recording the taxability of non-compete fee. So these were the 4 main grounds of appeal that was raised before the High Court, and nowhere specified whether non-compete fee could be taxed outside outside 22A, because the question that was raised before the High Court was only the differentiation between a revenue receipt or capital receipt, and nowhere it has been stated that whether a non-compete fee could be taxed outside the purview of 28(2)A. So in such cases, if ITAT is going to pronounce a judgment which is outside the substantial question of law that was actually raised, then in such cases it lacks legal validity. So that was the stance that was taken by Supreme Court. Supreme Court set aside the judgment of High Court, stating that SQL raised by the High Court did not contain any question whether NCF can be taxed outside 28(2)A or not, because that was not a question. Because what Supreme Court said was like you're supposed to answer only the question that was raised before you, and if you want to answer something which is outside the question, you have to follow specific procedures. And in case you are not follow the specific procedures, Supreme Court went on to state that I will set aside the judgment of the High Court. Then High Court went on to state, so that was a point with respect to a substantial question of law, and the case was set aside. But going further, coming to the merits of the case, Supreme Court observed the following points. High Court stated that the amount paid is so astronomical because the listed share price was only 3 rupees, but it was sold at rupees 30. So 27 rupees additional premium, that is something astronomical and huge. But the Supreme Court observed that in determining the test of commercial expediency, reasonableness of the expenditure has to be seen from the point of view of business and not from the revenue department. Supreme Court clearly said that what is astronomical or not has to be seen from the point of view of the business and not from the point of view of the revenue. Revenue cannot second guess the commercial expediency of what parties decide as arm's length. And the AO stands that Maltings Limited is not a threat to giant SWC. It's only the perception of the AO. It's nowhere the perception of a business reality. What could happen is once the assessee goes out of the CBDL, and he can very well join hands with Maltings Limited, and at any point in the future, he could develop Maltings Limited, and it could even be a competitor for SWC. So this reality was not even considered by any of the appellate forums before it came to the Supreme Court level. So So the AO was, as I said in the previous slides, AO was stating that this was only a sham transaction because a huge sum was paid to evade the taxation from the purview of 28(2)(a. But Supreme Court clearly stated that the shares were sold at such a huge premium because along with the sale of shares, even the control was getting transferred, and that is the reason why there was a huge premium. Sorry. So if the sale of shares was transfer of management, then the compensation of 6.6 crores in guise of deed of covenants should have been paid to the appellant sons and wife being the major shareholders. So NCF was paid only to the appellant and not to the other members of the family because it was the only the assessee who had the knowledge and the expertise to carry on or even a start a rivalry business which could be a competition for SWC group. The other members of the family did not have that expertise or knowledge, and that is the reason why a non-compete fee was paid only to the assessee and not to other members in the family. And Supreme Court also held that there was no colorable device involved in having two separate agreements. So the two separate agreements refers to one, the memorandum of undertaking, and number two refers to the deed of covenants for entirely two separate and distinct purposes. So Supreme Court went on to state that what gets covered within the ambit of 28(2)(a) is something like a loss of agency. So in Jailanda's case, the assessee was a sole distributor agent of a manufacturing entity. At one stage, he lost his agency right. As a result of that loss, he got a compensation. So this is something like a loss of agency, and loss of agency is a revenue receipt and gets covered within the ambit of 28(2)(a). But a compensation received for refraining from carrying on a business is a loss of source of business, and this is what you call as a non-compete fee. This is capital receipt. So in law, in Income Tax Act, a capital receipt is generally exempt in nature unless it's been specifically provided in the act. But a revenue receipt is generally taxable in nature unless an exemption is specifically provided. So this is the background upon which you should see this particular slide. So as I said in the first slide, this case relates to assessment year somewhere around 1994, 1995. Okay, so prior to Finance Act 2002, a non-compete fee was treated as a capital receipt and it's not taxable. But post Finance Act 2002, a non-compete fee is a revenue receipt from Section 28(5)(a) and is taxable as PGPP. So as I said, when the Act specifically provides that a non-compete specifically provides that a capital receipt is taxable, then it should be taxable. Otherwise, generally, it's exempt in nature. So before Finance Act 2002, it was capital receipt, so it wasn't taxable. But post Finance Act 2002, it's a revenue receipt and is taxable under the head PGPP. So coming to the conclusion, so as per the observations, it was held that the non-compete fee of rupees 6.6 crore received by the assessee was not taxable under the Section 28(2)(a), and non-compete fee is a capital receipt and is exempt from taxation. And the High Court shall formulate questions being substantial question of law and shall pronounce judgment only on the same. And if High Court wishes to hear an appeal any other, on matters other than a substantial question of law, it shall follow a specific set of procedures that has been prescribed in the Act as well as the Code of Civil Procedures. So this is the conclusion that is coming out of the judgment. So hope it was useful. I would like to conclude the presentation by saying thank you all.